What's up, America? It's your favorite Monday morning quarterback, Mr. White, back again with part 2 of Mr. Stua's story. Strap in and let's get started. We left off with the definition of a public servant, and that's where we'll start today. That's where that yet qualified or for office or assumed his duties comes in. See what this one says. This is from the Sentinel Alert, trying to get that video from the DA's office. She makes all kinds of, if you read that, let's see. This was, I believe, the second email when she came back. Yeah, common law privacy rights. So first she said it was exempt because essentially it was for, she basically used the laws that are for her when she creates a file, if she's to do a deposition and records a witness or something like that, some kind of work product. She tried saying that the December 6th video was a work product, even though it was filmed by David Stua in public and streamed live to Facebook. She's tried to claim it as a work product. So she comes back and she's talking about common law privacy rights. Again, this was filmed on a college campus in public by David Stua and streamed live. Like, what? I don't understand what common law privacy rights they think. This would be why that David Stua is still under these charges, is because there's an idiot running the DA's office over there, obviously. Let's go on. I digress. It's more about the video, trying to get it out of her. Just would not give it up. Still hasn't given it up. I haven't let Mr. Watson know that I have the video, mostly because I don't think he'll care. He's still going to want to get the video from her, just because when he sees this video, he's not going to believe that this is the video. It's crazy that they charged the man with what they charged him with. Let's see. What does this say? I was denied information by Judge White. The request was under the common law, not the Public Information Act. He never responded to my email or brief I filed before the court. This was December 5th, 2018. So that was one day before he did his video that he was arrested for. So that would have been almost a week and a day. It would have been a week and a day before he was arrested. I don't believe this was ever answered by him. This is the case number of the information he sought. State of Texas versus John Carter. Brief filed. I don't know if they ever had a hearing on that. So while David Stua was in jail, he tried filing his own motions because his attorney was not filing motions for him. The attorney was an attorney for him for almost a year. And the only motions that got filed, or at least the first few motions that got filed, were through David Stua doing it his own. So this is a court order not only denying Mr. Stua the right to be able to file his own motions, but sealing the motions he'd already filed and not requiring them to be heard by the court. They sealed them from public view. Let's see. It is further ordered that the court shall not schedule for hearing any pro se motion filed in this case in the absence of a formal request by counsel for the state or defense counsel, unless the court independently deems a pro se motion merits a hearing or upon consent of defense counsel. So he can't file his own motions. His attorney won't file motions for him. It's just, kangaroo court. Anybody? It is finally ordered that with respect to pro se motions and communications submitted by a defendant, David Ray Stua, the district clerk shall present same to the court's attention for review and action, if deemed meritorious, and thereafter file same under seal and not open for review as a public record except by counsel for state or defense counsel until otherwise released pursuant to a subsequent order of this court. So basically seal it off from everybody so nobody can know what he filed. Let's just go ahead and show Altrans's letters. Despite your personal opinion, the district attorney believes that she can prove all the charges and ask for stacked sentences. As I explained to you on the phone today, I do not need any more legal material from you. I will prepare any appropriate motions with the court based on Texas law. I will not allow you to review my work before I file the motion with the court. So he's his attorney. He can't file his own motions, and he also can't review his attorney's motions before he files it in the court. Mr. Stua is a paralegal. He went to school for being a paralegal. He is a I don't know if you license paralegals, but he is a paralegal. He knows what he's doing when it comes to the law. That's why they don't want him to file his own motions. That's why his attorney doesn't want him to review the documents. Al Chiranza currently is leaving town. He's getting the hell out. He got Mr. Stua to sign for the perjury charges, and he is leaving. If you want to file your own motions, then you need to represent yourself. That way you have no cause for inadequate counsel like Mr. Stua is trying to do now because his attorney didn't really work for him, or at least that's how it appears. I love this part right here. You are not in a position to dictate terms of a plea agreement. I don't understand how he figures that. If I am the one accepting the plea agreement, then literally I do dictate the terms. I say yes or no to whatever you present. If I tell you I will never take this, you have to take that because I'll never take it. You have to just take that one off the table because it's not happening. I mean, I do dictate the terms of a plea agreement. I'm the one that's going to have to deal with whatever the plea agreement is. So I do dictate the terms. You know, Mr. Stewart does dictate the terms. Yeah, this guy's a Marine also. I don't understand it. You must stop sending me legal material or letters of cases explaining possible defenses. Let's look here. If you decide not to accept a plea bargain, you will be going to jury trial until May 22, 2022, based on an email I received from Janet Cassels about the jail cases that her office intends to try during the next several months. You could be in jail 2 to 3 years waiting for a trial, which is what some inmates in Angelina County Jail have been waiting. Now, this letter, let's go back. This letter was sent August 21st, 2021. He was arrested December 2019. So he's already been 3 years waiting on trial. And it could be 3 more years before he gets to trial. He's in jail currently at this time when these were being sent. Your life will not change until you decide to take some accountability for your actions. You were out of line in your conduct on the Angelina College campus. You may have thought it was funny, but your statements and actions were offensive to some people. Oh my God! I'm sure glad the First Amendment doesn't protect offensive speech. It only protects that speech which is not offensive. Because, you know, that's the speech that needs protection, right? Oh, this stuff irritates me, man. You may have thought it was funny, but your statements and actions were offensive to some people, and not a laughing matter. Whether or not your conduct broke the law is a different issue. After looking at the Facebook videos again, others may have laughed because they were laughing at you and not with you. What the fuck does that matter? Like, you just want to take a stab at a man while he's sitting in jail? They may be laughing at you, not because they were laughing at your content. I mean, just, oh, this guy. They thought you were just some crazy old man. You have no boundaries of what is appropriate conduct. Appropriate conduct. You even offended a man on a bench wearing a suit by asking him if he worked for a funeral home. He thought the comment was offensive and you apologized to him. 2 women in the library were not comfortable with your actions and did not think it was funny for you to talk about your penis. He said circumcision. He was telling a joke. Not saying I am for circumcision, I can prove it, or I've got proof you want to see. Maybe a play on words. Most people will think that you are talking about showing your penis. This is perverted thinking. I agree. Most people that would think you're talking about their penis are thinking pervertedly. I guess we should punish the person, you know, it just blows my mind. This is why Janet Cassels, in her duty to protect the public, believes that you need to be monitored with some sex offender conditions. Funny, she dropped all the sex offender charges, all the sexual charges when he pled guilty to perjury, so she must not have really believed that. No one knows if you were joking or had some kind of weird sexual interest. Okay. You made a video of yourself being naked at Angelina College and approached a young man in his truck in another video implying that you were naked at the Angelina County Courthouse. Normal people do not act this way. You will need to be under some supervision conditions to prove that you are not a pervert and repeat your past conduct. Funny, he did not have any kind of supervision. Supposed to be just spending 4 years in jail and he'll be out loosed among the community. Now, this is Stua's attorney. This isn't the district attorney. This is Stua's attorney saying all this. You need to see that your actions have consequences, and some of your freedoms will be restricted until you can prove to the court that you can comply with the rules of society. Rules of society. This is a lawyer. He doesn't give a shit about the laws of our nation. It's rules of society. If society says that you are wacky or weird or in some way just not right, then you'll have to be restricted in your freedoms until you can prove that you can abide in those rules. This blows my mind. Your conduct so far shows that you will not follow any rules or social norms. Again, he's talking about rules and social norms. Like, this is an attorney. I just don't understand. So you are a risk to society and need to be locked up and removed from society. For exercising his First Amendment right to free speech, exercising his First Amendment right to freedom of the press, exercising his First Amendment right to redress grievances, and also his First Amendment right to free association. He was on a college campus. He got the cops called on him for saying the word circumcision, and so he decided to protest that, and by protesting that, he did some silly shit, which we'll see here shortly. Again, that's his attorney talking to him right there. It just blows my mind. So, yes, anybody wants to see any of these documents, hit me up, America First 77000 at gmail.com, America White on Facebook, America First on YouTube. So, Tranza becomes the attorney 6/6/2000. For a whole year, he did nothing. No motions, nothing. He was re-indicted on 7/23/2021. We'll play that one here shortly. So, motions list, we saw that. Let's go back up to all of Mr. Tranza's letters. Can anybody pause this and give me your answer in the comments? Who sets the motions for the dockets? Who is the one that decides the court's dockets? Anybody know? Pause, put your answer in the bottom. You don't get to win anything, I'm sorry. This is not one of those YouTube channels. Ooh, let's go back up. I want you to pay attention to this right here. I need to focus on the matters that are most in the current motions that I believe will need to be considered before any trial on count 1 to notify the court. When was this done? When was this letter sent? April 27th, 2022. April 27th, 2022. So this had been on the books since April 27th, 2022. This had still not seen court. An application for community supervision. So August, so that's 6, 7, 8 months. Still hadn't seen its day on the court docket. This one's 2 months old, still hadn't seen it. Because it could affect the potential jury pool. Yeah, we don't need promoting it because it could affect the potential jury pool. Yes, because when you go to Google and you type in David Stua, only nice things come up. Remember that? It was all nice things. It had nothing to do with agrees to prison, bond revocation, booked into Angelina County jail inmate, couple of, look, there's one good story. All the rest of these are negative stories. Yes, we definitely don't want anybody promoting his case to show light on the fact that they're railroading this man. He's charged with sexual performance by a child. Definitely don't want anybody promoting good stuff about him because there's so much of that negative stuff out there. We can't have anybody talking about that. And place facts and opinions in a news medium that is not subject to expulsion of laws of Texas. If you are acquitted of the charges and they are dismissed for insufficient evidence, law enforcement and state agencies must destroy their files. This law does not apply to the media, who have a First Amendment right to report whatever they want, whether true or not true, accurate or inaccurate, or false. Too many times the media do not report all the facts and therefore provide an improper impression to the public. Absolutely, you're right. As proven here, they don't even give a shit. Whatever the boots spoon feed them, whatever leather and polish the boots feed them, they will just, oh look, there's mine. They will just put it out there for the masses. We definitely don't need anybody reporting that David Stua is being bent over and not even given a courtesy reach around. Don't want that, because he's talking about me in that particular letter. I'm positive of it. Yep, that's my my other account. I hadn't even read this letter yet. On June 1st, 2022, I received an email from Richard Gozinia asking me to comment on my letter to you dated August 31st. I have enclosed a copy of the letter he attached. I do not know how he obtained our confidential communication. Richard asked me if I had any comments on this or why your client's unconstitutional bond conditions have had him in solitary confinement for 386 days. As of today, especially considering there's plenty of case law showing him to be applied to his email, I do not know who you are, how you obtained a copy of my confidential blah, blah, blah. David Stua, I have no authority to discuss any matters of this case with you. If you have any case law do you believe is relevant. Mr. Stua has sent you case law that is relevant. But you're telling him you don't want it. Why would I send you stuff when you're telling the guy whose life is on the line, who could possibly is facing 4 years of TDC? You don't want any case law from him. Why would I send you any? It would be a complete waste of my time. It's obvious, as shown. You went to court and made sure that his motions were not part of the court record. You didn't fight for David Stua's motions to be able to be in the record. You didn't fight for David Stua's motions to be able to be heard in court. You helped seal them. You helped the judge and the DA keep this man's own work, own case laws, own all that. And then you tell him that you don't want him to send you case law. Why would I send you case law? Richard Dick Gozinia replied and claims he is just a journalist gathering information for a story on unconstitutional bond conditions. He also stated that he believed that the comments in my letter made him believe that I was working for the state and not you, and that I wanted you to represent yourself. I mean, it does seem that way. I will not be commenting or responding to this person who claims to be a journalist. He did not list an agency. My agency is First Amendment. Address or telephone number. I do not think you want any publicity in your case based on your messages to me this week. I am not going to comment on this letter, which was written 9 months ago and at a very different time of my representation and the information that I had in your case at that time. On August 31st, 2021, I was trying to have you see the facts of the case as a potential juror may see in a trial when considering the plea bargain that would have resulted in release from jail if you accepted it. You did not accept the offer, which was your decision, and we continued to fight the case as we will in the future. Yeah, you didn't fight very long before you had him sign something, did you? Let's go back to that. Hold on. I don't really like the way this guy's talking about me. And he seems to think that we must have misconstrued his words. Let's go back and see where he talks about how this is how a jury will see you. Come on, where's my zoom? All right, zooming in, going down here. We'll just go down right here. You need to see that your actions have consequences, and some of your freedom will be restricted until you can prove to the court that you can comply with the rules of society. Your conduct so far shows that you will not follow any rules or social norms, so you are a risk to society and need to be locked up and removed from society. Sincerely, Albert J. Chiranza, Jr. That's his signature. Nothing about this is how a jury sees that you need to be. No, none of that bullshit that you just claimed in your other letter. That is you saying you believe he needs this and he needs that because he can't go into social norms or follow any rules of society. Rules. We do not need a media or news promoting your case because it will affect the potential jury pool. Yeah, it's already affected the jury pool. He's been blasted for the last 4 years saying he's a sex offender, that he induced a minor. He tried to solicit some kind of sexual. He's some kind of sexual deviant. He tried to solicit a minor into looking at his peckers, what y'all claimed, or what I'm sorry, not what y'all claimed, Mr. Chiranza. You weren't on the case at that time, although it doesn't seem like you're really fighting what they're claiming. The state claimed that he induced a minor to look at his penis. We do not need media or some other news source promoting your case because it could affect the potential jury pool. Blah, 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 blah. We already read all that. So, too many times the media do not report all the facts and therefore provide improper impression to the public. Richard Gozinia was asking about unconstitutional bond conditions and how this man is set in jail for almost 400 days. Let's see what KLTV reported. Judge upholds bond revocation for former Angelina County political candidate. Judge Paul White's order comes after the district attorney's office filed a motion to revoke bond for David Stua, 58 of Lufkin. Stua was initially arrested in December 2018 after he was accused of asking a high school student if the student wanted to see his genitals. That is very important. This person, this is May 14th, 2021. This person just, took the boot, got the spoon, took the leather and the polish, and just lapped that fucking shit up. Sorry, excuse my language. It just really irritates me when these so-called journalists don't do any investigation. They just, whatever the state spoon feeds them, they just report it. I mean, I'm just saying, at this time, whoops, wrong button. At this time, this information, this warrant was available. It was public information that this journalist, so-called journalist, could have requested and got. As we all watch the video, this is Doug Kahn of the Angelina College Police Department, chief of the Angelina College Police Department, and also the head of the police academy out there. As we all watch the video, I could tell that Mr. Stua was confronting random individuals and promoting them to read a sign that he made of paper that was taped to his shirt in front. As he approached several different individuals, he would make the comment, "I'm for circumcision, snip, snip." This is very important because in the video that I'm going to show, I highlighted every time he used the word snip, snip. He never uses these words together. He never says, "I'm for circumcision, snip, snip." He might say, "I'm for circumcision," long pause, and then snip, snip after. But he never actually uses these words. So there's the first lie in his affidavit, that this is a police officer that trains other police officers on how to fill this stuff out, lying on an affidavit. And wait to see if there was any response. Throughout the live feed, now remember, he says he approached several different individuals, he would make the comment. So he doesn't just say it once, or he says it several times. That's more than twice in my understanding of the word several. Some responded, just looked at him without verbally responding. On 3 specific occasions, he would engage the individual verbally, and if the person he was speaking to responded, he would tell them, "I have proof," and then ask them, "You want to see?" In each instance, the individuals would respond no. One of the individuals, there's an S there, sir, that Stua actually chased down, and we're going to see this here in a little bit. He didn't chase him down. Chase implies that somebody's running from somebody. The other person's running after the person. Like a chase, as I understand it, is like a police chase. Somebody runs from the police chase the person. A chase is not somebody walks away and another person speeds up to talk to them, which is what happened. But we'll get to that here in a minute. Okay. One of the individuals, there's an S there, sir, that Stua actually chased down to talk to was later identified as a 15-year-old dual credit student who regularly attends Piney Woods Community Academy. That's a high school there in Lufkin. As he, Stua, ran after the student, I would struggle to call what he did running. He, Stua, was talking to listeners of the video saying, "Look, he's running away. He must not be circumcised." Now, that's very important too. As he, Stua, ran after the student, he, Stua, was talking to listeners to the video, saying, "Look, he's running away. He must not be circumcised." Again, this is another lie in this affidavit, which does not surprise me because, wait, I'm going to show you the arrest warrant too. But we'll get that in a minute. I jumped to this a little early because I'm irritated. It was later determined that at that moment, Stua was speaking about a 14-year-old male student. When Stua caught up with the student who was not running away, he stated, "Pardon me, sir, but has your friend been circumcised? He's running awful fast." The male student then responded verbally by stating, I don't know. It's funny how they left out how Mr. Khan here, who is teaching other officers how to write these reports, conveniently left out the student says, "I don't know." Stua says, "You don't know." And then the student says, "I don't know." It wasn't just, I don't know, like he's scared. It was, "I don't know." Stua says, "You don't know." And the student says, "I don't know." Stua then asked him, "You ain't checked him out?" The student then said, "Nope." Stua then went on to tell the student that I got the cops called on me for saying the word circumcision in the library, so I decided I'd be for circumcision. Stua then repeated, "I got proof." The student said, "You do?" Then Stua stated, "Yeah, you want to see?" The student said, "No, I'm good." During that exchange, the Stua was speaking to a 15-year-old male. I later determined the exact age of the student by speaking with officials at Piney Woods Community Academy. They issued a warrant, yada, yada, yada. So the reason I bring up who sets the motions for court is because the court clerk up in Angelina County is Reva Squires. Everybody in this case has some kind of link. Everybody, especially on the county side, has some kind of link to Mr. Stua's investigations. Common law access to court records attachment sent to her on June 11th. Scroll down. Reva Squires requesting records. John Carter attachment Fort Bend, June 2021. Common law access to court records and exhibits. This is an email sent to District Clerk Reva Squires for court case records. The email went unanswered. This is a big three-part. There's some nice emails here. That's Mr. Stewart. This is Joe Martin. He's no longer on the case. He was replaced by Janet Cassels. But there's some nice emails here. J. Martin, P. White. That's Judge Paul White that is currently, or was currently, over his case. B. Inselman, I'm not sure if he's still there. Reva Squires is still there. Wes Hooter is not. I'm not sure about that one. I'm not sure about any of these. But there's some emails, so you can try them, Throw them up there, see what happens. This is about Austin Huffman. Public information request turning off from Huffman. This email is apology to you and Assistant Attorney John Peralta. Public information request took so long. Much time have you indicated? This would have reduced your burden. I wanted to have the court records as well. Reva Squires continues to block access to electronic court records, which otherwise would be available to public online, thus permitting full access by the public and reducing the amount of requests to her office. Reva Squires continues in this abusive behavior in retaliation to me and being indifferent to the additional work others, such as yourself, has to do to fulfill information requests. She's severely lacking in understanding of what public service means. For many years, she hasn't shown up at work. I've only seen her in her office one time in the last 4 years or more. At one time, I did see her. I had a conversation with her. In retaliation for me requesting public information from her in the conversation, she proceeded to the security officer's station. She told them in reference to me that she is scared for her life. It is a shame with many hardworking elected officials having to work so hard and so many hours while she is lazy and indifferent. I believe she draws $60,000 a year salary, which she does not earn. I recall several years ago at a budget workshop meeting, Constable Trey Trevathan requested an increase in his budget. The increase was met with strong opposition by several commissioners. It was claimed Trey didn't do anything. Therefore, he should not receive an increase. If this requirement of doing something is method for determining budget increases, then Ms. Squire's salary should be greatly reduced. If I had won Commissioner Precinct 2 in the recent election, be rest assured her salary would have been on the chopping block. Recently, Judge Paul White told me he's seen 160 people in a day. I have spoken to you on Friday nights around 9 p.m. on the phone while you still work in the county business. Many elected officials in this county work many hours, dedicated themselves. This email is a sincere letter of apologies to you both. I believe apologies should not contain excuses for one's behavior. It is not right to say I apologize, but unfortunately I think I did make excuses. Please forgive me. I'm laying the blame squarely on Mrs. Squires. This email is being sent to a number of people, including the commissioners and the county judge, so perhaps someone can encourage Ms. Squires to conduct herself in an ethical and moral way. She is getting a copy of this email as well. I do not want to say anything behind her back, and I wouldn't say to her face if I ever could see it. Respectfully submitted, David Stua. So there's Reva Squires being a pain in Mr. Stua's side. Common law access, again, Reva Squires. He still wants to charge me $1 per page. Oh yeah, this was funny. Charges for copies, case John Carter. Ms. Squires, we have been round and round about this issue many times before. You are trying to charge me $1 per page for the court case records in the above styled and captioned case. I am not requesting paper copies. I am not requesting blah, blah, blah. Do you understand? I am not requesting paper copies. I want electronic copies. I think this can all be charged up if you take the time to read the Texas Clerk's Manual. I have included an attachment. Y'all can read all this. Pause it and read it. I'm not going to sit here and read it all. Basically, the court clerk has a demonstrated dislike for Mr. Stua, so it may be the reason that his motions never got put on the court docket. Sure would seem to coincide with one another, I believe. Again, pause and read these. Texas, increase access to the Squires again. Again, pause and read. I mean, she just doesn't want to give access to records, and now apparently she didn't want to put his motions on the docket, from what it looks like. This is a picture of David Stua with his certificate of circumcision that he had made up. A little close-up of it. Trying to get the originals, but it's a little difficult. Alright, so now we're getting into the days before his infamous December 6th video. And I'm sorry, guys. Sorry, America. But I think that's a good place to stop for today. Another 33 minutes on the books. Make sure you come back tomorrow for hopefully the final one. I'm not sure. I'm still cutting all this together. But it has been a joy to do it. I'm really glad to shine some light on this. I hope everybody shares this as much as possible. And I will holler at y'all later. Stay free, America. Out.